Hello friends, I am Vivek Nahadia. I am a chartered accountant company secretary. You can contact me on cavivek68@gmail.com. I hope you find this video useful. Thank you for watching. Hi, in this video we are discussing lectures on labor and industrial laws. I am using a book in this video which is prepared by me. This is the paper 5 of 3rd semester, LLB 3 years. What are the advantages of this book? It is in a very simple language. It covers almost the entire syllabus. All the previous examination questions are covered. This book covers almost all the important questions. It is a colored notebook, and this notebook will be along with videos which will be uploaded on YouTube. I will use the same book in the video for teaching, so it will be very easy and convenient for you to understand. Disclaimer: selection of important questions is based out of my in-depth research, and I don't guarantee anything. You can download this book by clicking on the link provided in the description. I have given a link just below the video. You can see product video description. In that you will find a Google link. Click on that and download the book and start watching the video. Thank you.
Model standing order. We are a model or example of standing order made by the government. Government makes an example of standing order. On this basis, the employer makes his own standing order. So model standing orders are what the name itself suggests. Model means an example. An example is given by the government. Government makes this model standing order. Taking this model as a base, employer of an industry prepares his own standing orders. They mean the standing orders prescribed in the Act. These model standing orders are the standing orders which are prescribed in the Act. And based on this, the employer prepares his own standing orders. Contents of the model standing order. What are the contents? Publication of working time. Working time will be mentioned in the standing order. At what time the employee should come to office, at what time will work. So entire working time will be mentioned. Publication of list of holidays, what all the employees will be getting, the workmen will be getting. And publication of wage rates. What are the wages that employees will be getting. So what is the model standing order? Model standing order, as the name itself suggests, it's a standing order. It's an example of standing order given by the government, and based on this the employer prepares his own standing order. What are the contents? Contents are 3: working time, holidays, and wage rates. Similarly, other points also will be there.
In the earlier questions, we have discussed the registration process of a trade union. Now we are discussing the advantages of a registered trade union. Why a trade union should be registered? What are the advantages of registering a trade union? First, it becomes a juristic person. Juristic person means, though it is not a person in real, it is not a human being, it is not a natural person, but in the eyes of law, it is a person. It has all the rights and liabilities a normal person has. So, in the eyes of law, it is a person. So, it is called a juristic person. It can sue and can be sued in its own name. The registered trade union, suppose the name, it can sue means the company can sue the third parties. They can file a case against the third parties in court. And whereas the third parties can also file a case against the company in its own name. Suppose the name of the company, the name of the trade union is suppose AB. So in the name of AB, the trade union can file a case against the third parties, and the third parties can file a case against in the name of AB. It has perpetual succession. This most of the characteristics, most of the advantages that we are seeing of a trade union are similar to the advantages of a company. If you say juristic person, it is an advantage of a company. Sue and can be sued, advantage of a company. Perpetual succession, acquire properties, contract. Actually, all these properties, all these advantages are advantages of a company. That answer itself, we can write it here. perpetual succession. What is the meaning of this? The company goes on forever. The members may come, the members may go, but the company goes on forever. That's the point here. We have read that 7 members form a registered trade union, right? If 7 members, all 7 die also, it doesn't have the existence of the registered trade union is not affected. It will continue like that without any issue. It is called perpetual succession. It goes on forever. The members may come, members may go, but the trade union will go on forever. Acquire properties in its own name. AB trade union can acquire the properties in its own name. In the title deeds of the properties, AB trade union name can be mentioned. Can contract in its own name. All the transactions, all the contracts can be done by the registered trade union in its own name. So it has a separate legal identity. Registered trade union is different and its members are different, though the members themselves have formed the trade union. So let's do a recap. Advantages of trade union. The advantages are similar and exactly like the advantages of a company. First, it is a juristic person, can sue and can be sued, perpetual succession, acquire properties in its own name, and right to contract. Retrenchment. Retrenchment means what? Discharge of surplus labor. When an employer has a surplus labor, he can discharge those laborers. This is important here, surplus. You have tried this in exam. There must be termination of service of a workman by employer. Employer must terminate the service of workman. It may be for any reason. If the surplus labor is discharged because of these reasons, then it is not called retrenchment. Except these reasons, any reason the surplus labor is discharged, terminated, then it is called retrenchment. So what are these reasons? Punishment, voluntary retirement, retirement on reaching the age of superannuation, termination as a result of non-renewal of contract between the employer and the employee. There is employment contract between the employer and the employee, and that employment contract is not renewed. So the services of the employee gets terminated. Okay. So if that is not renewed, it gets terminated. So that if there is discharge of the laborer, termination of the employment of the laborer because of this non-renewal of contract, then it is not called retrenchment. Except this, any other reason, then it is called retrenchment. Termination on account of continued ill health. So 1, 2, 3, 4 and 5. Except these 5 reasons, any other reason the surplus laborer is discharged, then it is called retrenchment. Difference between layoff and retrenchment. Layoff is temporary. Layoff is temporary. Industry stops its function. All or a group of employees are refused employment. Laid off compensations are paid. This is compensation. Laid off compensation, here gap should be there. Laid off compensation is paid. All the laid off employees should be taken back in their usual post later. So what is layoff? Layoff means temporarily the employees are laid off and again they come back after some period. So during this time, laid off compensation is also paid. Retrenchment. Retrenchment is permanent. Layoff is temporary. After the layoff, again the employees can come back. Retrenchment is permanent. Industry does not stop its function. Industry does not stop its function. Retrenchment compensation is paid. Not mandatory to reappoint the retrenched workman. When the employer retrenches the workman, then it is at the option of the employer to appoint the workman or not. But in layoff, he has to. It is mandatory for the employer to reappoint the laid off employees. That is the difference between the two. Let's do a recap. Difference between layoff and retrenchment. Layoff is temporary. This is permanent. In layoff, industry stops its function. In retrenchment, industry does not stop its function. All a group of employees are refused employment. Laid off compensation is paid. Here retrenchment compensation is paid. It is mandatory for the employer to hire back the employees after the layoff period. It is optional for the employer to take back the employees, retrenched employees. Works committee. It shall be constituted under the following circumstances. In these circumstances, the works committee is constituted. Establishment must be an industrial establishment. The establishment must be an industry. There must be 100 or more workmen. Only for big industries, work committee provisions are applicable. Appropriate government may require an employer to constitute a works committee. Appropriate government may require. So it is at the discretion of the appropriate government whether the employer should constitute a works committee or not. Constitution of works committee. Representatives of employer and employees. This is an employer. These are the employees. So this group has a representative. Employer also has his representative. So representatives of employer and employees, number of representatives of workmen shouldn't be less than the representatives of the employer. So number of representatives of the employees, suppose they have 3 and they have 4, then it is not correct. It is the violation of the provision. The representatives of the employees should be equal to, if this is 3, employer representatives also should be 3. If employer representatives are 5, the representatives of the workmen should also be 5. If they are 5 and workmen representatives falls to 4, then it is violation. Number of representatives of the workmen shouldn't be less than the representatives of the employer. There must be equilibrium between the two forces. Why it shouldn't be less? Because already the employer is in a higher position or a strong position. If his representatives exceed the number of representatives of the employee, then again the workman will become less stronger. To balance that, to have an equilibrium, the act says that the representatives of both the parties should be same in number, or the representatives of the employees can be greater than the employer, then not an issue. But the representatives of the employer cannot be more than the employees. Representatives of workmen shall be chosen from workmen engaged in establishment and in consultation with a trade union. How are the representatives of the workmen selected? From the group of workmen who are working in the establishment, and discussions happen with the trade union, and as per their recommendations the representatives are selected. Purpose and object. The primary purpose of works committee is to settle the disputes between the employer and the employees and to improve national economy. What is the primary purpose of works committee? To settle the disputes. Number of members of the works committee should not exceed 20. So maximum number of representatives of both the parties should be 20. Term of office is 2 years. Meetings, at least once in a month they should meet. Works committee is constituted in the following circumstances. What are the circumstances? It should be an industry, 100 or more workmen, and then the appropriate government may require the employer to constitute a works committee. How is it constituted? Representatives of both the parties are taken on board, and the representatives of the employees or the workmen shouldn't be less than the representatives of the employer. How are the representatives of the workmen selected? From the workmen who are engaged in the establishment and in consultation with their trade union. What is the purpose? To settle the disputes. Maximum number of members in the works committee is 20. What is the term of office of the members? It's 2 years. And meetings are conducted once in a month. Conciliation. Conciliation is a process by which a third party encourages the parties to an industrial dispute to come to a balanced conclusion. The parties to an industrial dispute, third party encourages the parties to an industrial dispute to come to a balanced conclusion. There's a dispute happening between the employer and the employee. So third party comes and he says that the people who are in dispute then can come to him and he tries to give a balanced conclusion. So conciliation is a process. It is like an arbitration. Conciliation is a process by which a third party encourages both the parties to an industrial dispute to come to a balanced conclusion. The decision is given in the form of an agreement. He prepares an agreement with both these parties. The Industrial Disputes Act focuses on settlement of labor and management disputes with the help of a third party. The entire Industrial Disputes Act focuses on a third party coming and settling the disputes. Even in a normal cases we find this. If two friends are fighting, a third friend comes and settles the dispute between them. This is exactly like that. Under the Act, conciliation is compulsory in all disputes in public utility services. We have discussed this already. Why is conciliation compulsory in public utility services? Why? Because public utility services mean the services which are most essential to public at large. Hospitals, railways, postal services. So these are the public utility services. If strike is happening in these services, then it is a huge setback to the entire economy of the country. So conciliation is compulsory because conciliation is very faster. If the matter goes to the court, it takes a lot of time, lot many years for the matter to get solved. That's why conciliation is compulsory for the disputes arising in the public utility services. There are two authorities set up for conciliation. For conciliation, two authorities are set up: Conciliation Officer and the Board of Conciliation. Conciliation Officer is there and Board of Conciliation is there. So what is conciliation? Conciliation is a process where a third party comes and settles a dispute. And if the dispute is in public utility services, then conciliation is mandatory. There are two authorities set up in conciliation: Conciliation Officer and the Board of Conciliation. So in conciliation there are basically only 3 points. First point is the definition. Third party is coming and settling the dispute. Second point is settling the dispute and preparing an agreement. Second point is if it is a public utility service, then conciliation is compulsory. Third point is authority set up. There are two authorities: Conciliation Officer and the Board of Conciliation. That's it. Voluntary arbitration. Voluntary arbitration. It is a way to employers and employees to settle the disputes voluntarily by way of arbitration. The employers and the employees voluntarily, they themselves go to arbitrators and settle the disputes. They can refer the disputes to arbitration by an arbitration agreement. The employers and the employees prepare an agreement, arbitration agreement, and they refer the dispute to arbitration. They can refer the dispute to arbitration provided the dispute has not been referred to labor court. If the dispute has already gone to the labor court, then we can't take it to arbitration. If the dispute has not gone to labor court, then we can take the dispute to arbitration. The arbitrator shall investigate the dispute and submit the arbitration award. Arbitration award is nothing but a decision. Arbitration award duly signed to the appropriate government. So what is voluntary arbitration? Very simple point. Employers and employees, the name itself suggests it. Again, we'll go by the name. It will be easy to remember during the exam. Voluntary arbitration. Voluntary means without any force or compulsion, they themselves go. Voluntary means what? They themselves go. So employers and the employees, they themselves go for arbitration. Correct? And they make an arbitration agreement. That is the second point. First, employers and employees go voluntarily for arbitration. Second, they make an arbitration agreement. Third, the arbitrator will investigate the dispute and gives the arbitration award to the appropriate government. Fourth point, the dispute can be taken to arbitration only if the main condition, only if the dispute has not been taken to the labor court. If the dispute is pending at the labor court, then we can't take it for arbitration, because labor court is a higher authority. When the dispute is already pending with the higher authority, we can't take it to the lower authorities. Unfair labor practice. The name itself will give you an idea of what we are about to discuss. Unfair. Okay, unfair means which is not reasonable, which is not correct, which is not fair. Labor practice means the employers or the employees are doing some act which is not fair. That is called unfair labor practice. Let us read the exact provisions. General meaning: practices which are not fair. Clear? Unfair labor practices mentioned in the 5th schedule of the Act. In the fifth schedule, this a list of unfair trade practices is given. What is the advantage? It saves the workers from the exploitation of the employers. At the same time, it saves the employers from the unfair trade practices of the trade unions and workers. So both the parties, the employers and the employees, both are saved. No employer or workman or a trade union, employer, workman or trade union, whether registered or not, shall commit any unfair labor practice. Employer, employee or trade union should not commit any of the unfair labor trade practice. Unfair labor practices as mentioned in the 5th schedule are unfair. As I said, there is a list of the unfair labor practices provided in the 5th schedule, and it is divided as on the part of the employers. This is the list. Employees shouldn't do, this is the list. What trade unions shouldn't do, this is the list. So on the part of the employers, what employers shouldn't do: threatening workmen with dismissal if they join trade union. Threatening the workmen that if you join the trade union, then I'll remove you from employment. This is not right. This is unfair labor practice on the part of employers. Threatening a closure. If a trade union is organized, if you organize a trade union, I'll close and you will be removed from employment. A whole bundle of the employees will be removed from employment. Granting wage increase. Wage is increasing for whom? To workmen at crucial periods of trade union meetings. Whenever, as we have discussed, the trade unions will have their own meetings. Okay. So at the crucial period of the meetings, what the employers are doing? They're increasing the wage rate. So in the meeting, they have nothing to discuss because everybody is very happy. So this is also unfair trade practice. Punishing a workman because he made even other workmen to join the trade union. A workman is there, he made other workmen also to join the trade union. So what the employer is doing is dismissing this workman. This is unfair labor practice. Dismissing a workman for taking part in the strike. If the worker is taking part in the strike, then the employer is dismissing the worker. This is not right. Changing seniority rating of workmen because of the trade union activities. If suppose a senior employee or a workman is there, generally we find that the seniors of the organization are the main leaders of the trade unions. So what the employer is doing, because the senior employee is taking part in the trade union activities and disturbing the employer, he is changing the ranking. He is giving a lower level employee and better opportunity of promotion higher than the senior employee. So this is an unfair labor practice. Or refusing to promote workmen because of the trade union activities. So basically, the participation of the workmen in the trade union, those activities should not have any impact between the relation or employment of the employee and the employer. Just because he is actively participating in the trade union activities, organizing meetings, pursuing other workmen to join the trade union, the employer cannot punish this workman because the activities of the trade union are separate and the employment activities are separate. To transfer a workman, suppose if the employer is seeing that a particular employer or a workman is participating a lot in trade union activities and his group is becoming very strong. So with a threat, this is a very, very risky situation for the employer's point of view. If you imagine you are an employer and you see that your own employees are forming trade unions and they are becoming very strong, then it is a headache or tension for you, because no matter if you try to implement any new thing, they'll form a group and they'll protest against it. It will be very difficult for you to manage your business. So what they do, they look for the workmen who are actively participating and who are the main leaders of this. So what they do, they pick up those workmen and they transfer them to some other branch or some other state of the business. By this, the entire strength of the trade union gets disturbed. The main leader is gone somewhere. And this is an unfair labor practice. To transfer a workman, malified means with bad intention, not on genuine grounds, to show favoritism and partiality. A workman is there who is not taking part in trade union activities. Another person is there, he is taking part in trade union activities. So what the employer does, the workman is not taking part in trade union activities, he is showing favoritism. He is a friend of the employer, he is showing favoritism, he is promoting him, then discriminating from the person who is taking part in the trade union activities. This is an unfair labor practice. What are the unfair labor practices on the part of the workmen and the trade union? Commence illegal strike. Commencing illegal strike is an unfair trade practice on the part of the workmen and the trade union. To involve in coercive activities. Coercive activities means they are threatening the employer. Coercive means physical force or something. To stage demonstrations at the residence of the employer. The employees of the trade union are going to the residence of the employer and protesting in front of the gate. This is not allowed. This is unfair trade practice. Damage of employer's property. In that group, they are damaging the properties of the employer. That they went to the residence, they saw the employer's car, they threw a stone on the car and the windshield broke down. All these activities are unfair. You cannot damage the properties of the employer. You cannot go to his residence to involve in acts of violence. They are encircling the employer and they are protesting him, they are hitting him, or all this nonsense they are doing. So this is not allowed. So let's do a recap. Unfair labor practices, what? The practices which are not fair. These practices, this list is given in the 5th schedule. What is the purpose of this unfair labor practices list? It saves both the parties from exploitation. This 5th schedule has 2 parts. Unfair labor practices on the part of the employers, unfair labor practices on the part of the workmen or the trade union. For the employers, they have given, just because a workman is participating in trade union activities, you cannot discriminate that person, you cannot transfer, you cannot remove him. All these activities you can't do. And on the part of the trade union, to summarize what we have read is that they can do genuine or legal strikes, but they cannot do illegal strikes. They cannot go to the residence of the employer. They cannot destruct the properties of the employer. All these are not allowed. Victimization. Again, read the name properly. Victimization. Victimization, what can you imagine? What could be the meaning under it? Victimization. A person is becoming a victim of somebody. A person is becoming a victim of someone. That could be the essence of this concept. Let's read. Worker who has become a victim of unfair action taken by the employer by reason of his trade union activities is called victimization. As we have discussed, the entire labor law is very, very simple. The question itself will give you the answer. If you read the question properly, you'll get the answer. So what is victimization? Just now we have discussed. Suppose a person is there and he is becoming a victim of somebody else, then it could be victimization. That itself is the answer. Just put the proper terms in it. What will do? How will change this answer? A person is there, he has become a victim of somebody. An employee is there, he is becoming a victim of the employer just because of his trade union activities. This is the victimization. The worker is made a victim and is subject to prosecution, harassment, or punishment for no mistake of his own. He has not committed any mistake. He has just taken part in the trade union activities. That's it. It is an unfair labor practice on the part of the employer. It is done by an employer to punish an innocent worker just because of his trade union activities. Victimization. A worker becomes a victim of the employer just because of his trade union activities. This is an unfair labor practice on the part of the employer to punish the innocent worker. Recovery of money due from employer. Where any money is due to the workman from an employer under a settlement. There was a settlement and there was some money due to the workman from the employer. The workman himself or any other person authorized by him can make an application to the appropriate government, and if the appropriate government is satisfied that the money is due, it shall issue a certificate for that amount to the collector, who shall proceed to recover the same as an arrear of land revenue. Let us read this slowly. There was a settlement between the employee or workman and the employer. As per this settlement, there was some money due to the workman. So what can happen? The workman himself, or he can authorize somebody else. They can go to the appropriate government, and if the appropriate government is satisfied, they issue a certificate to the collector, and collector will proceed against the employer and collects this amount by following the process of arrear of land revenue. So what is the recovery of money due from employer? There was a settlement between the employee and the employer, and as per that settlement, money was due for the employee. So the employee himself or authorize somebody else, both can go, either of the persons can go to the appropriate government along with this settlement. If the appropriate government is satisfied, it issues a certificate to the collector, and the collector will recover this amount from the employer, like the arrear of land revenue. Simple. Principles of natural justice. Principles of natural justice are the principles formulated for good standards. They are judge-made laws. Natural justice is not a legislation, it is not an enacted law. These are the judge-made laws. They are not converted into legislation, yet they have their own values. Though these are not legislation, they have their own values. Three important principles of natural justice are: no one shall be judge in his own case. In his own case, he can't be a judge. Why? Because if he is a judge in his own case, then he cannot give a right decision, he will give a biased decision. These we have already read. No one shall be punished unheard. Punished, if you want to use a better word, you can use condemned. No one should be condemned. D-E-N-M-E-D. No person should be condemned unheard. The judge has to hear both the parties, and then only he has to give the decision. He cannot give the decision unheard. A party is entitled to know the reasons for the decisions. What are the decisions the judge is taking? The party is entitled to know the reasons, the basis on which you are giving such decision. And there is one more principle, which is the person who hears the parties, he only can give the decision. Suppose a judge is transferred, he has already done a few hearings and is transferred to some other place. Then what happens? A new judge is appointed in his place. So the new judges should also read the entire cases, the files which the old judge has prepared, and understand what is the case about, then put a hearing of both the parties and then give a decision. So he who hears should give a decision. Crux. Principles of natural justice, it is not a legislature, it is a judge-made law. There are three important principles, actually four. First one is that no one can be the judge in his own case. Second, no one can be punished unheard. Third, he who hears can give the decision. Fourth, a party is entitled to know the reasons for the decision. Closure of industry. Closure means permanent closing down. Till now we were seeing the concepts of temporary close down. Closure is a closure is a permanent closing down of a place of employment. What is the procedure for closure? This is a very big thing. If the employer does a closure, it is a drastic impact. A lot of people will get unemployed. So there has to be a particular procedure to be followed by the employer before declaring a closure. So what is the procedure? Prior permission. Employer who wants to close down an undertaking has to first apply to the appropriate government and seek prior permission. Before the closure, the employer has to apply to the appropriate government and take permission for closure. Why permission is required? What do you think? Why this is required? Because this is a permanent thing. If today the employer thinks that he wants to work, and tomorrow he feels that no, I want to close down this business, and a lot of employees are terminated. So it will be a drastic impact on the employees. They'll face a lot of problems in their day-to-day life because they won't have money to spend. So this is very important. This is a very crucial thing. It's not a temporary thing that we are talking about. He should clearly mention the reasons for the closure in the application form. When the employer gives the application to the appropriate government, he should clearly mention the reasons for closure. He should give a copy of such application to the registered trade union. He should give a copy of this application to the registered trade union. So what is prior permission? Before closure, employer has to make an application along with the reason to the appropriate government, and even give a copy to the registered trade union. Now, after receiving the application, what is the duty of the appropriate government? The appropriate government, on receipt of the application, the government should make an inquiry. Inquiry is there are two things. Enquiry and inquiry, both are different. Note down. Enquiry is different and inquiry is different. Inquiry is like an investigation, very in depth. Inquiry is like an investigation, very in depth. But enquiry is just a normal procedure to find out the reasons and all. It is not so in depth. So what we are using here? The appropriate government on receipt of the application should make an inquiry. It is like an investigation. It shall give reasonable opportunity. Reasonable opportunity should be given to the employer, employee and others. If they have anything to discuss, if they have any objections, they can discuss. It shall adopt the principles of natural justice should be followed. If satisfied, it passes an order of close down. A copy of the order shall be sent to the employer and the workman. What we have read here? Appropriate government. After the receipt of the application form by the appropriate government, it makes an inquiry. Then it gives opportunity to both the parties. Then after that, if it is satisfied, it passes an order and gives it to the both parties. The order is given to the employer and the order is given to the trade union also. Binding force. Such order shall be final and binding on all parties concerned. Review of order. Appropriate government, either on its own motion or by an application review, its order of closure. Illegal closure. What is illegal closure? If the employer closes down the establishment without prior permission, it is illegal closure. Compensation on closure. Every worker is entitled to receive compensation. Because why are the workers entitled to receive compensation? It is very obvious. Because this is a very big thing. It is a permanent closure of the business. We are talking about a lot of unemployment will be there. So the employer is bound to give compensation to the workman. So what is closure? Closure is a permanent thing. Permanent closing down of the place of employment. So what is the procedure? Before the closure itself, the employer should give an application to the appropriate government along with the reasons. That application's copy should be given to the registered trade union. After receipt of the application copy, the appropriate government will make an inquiry, and after that, if satisfied, it gives order of closure to the employer and the registered trade union. The binding force, it is conclusive and final and binding on all the parties. Review of order can be done by the appropriate government either on its own motion or by an application made by anybody. Illegal closure without permission, without taking prior permission, the employer closes down the business. Compensation, every worker is entitled to compensation. Labor courts, what are labor courts? Constitution. Appropriate government may constitute labor courts. Labor courts shall consist of one person. Such person shall be appointed by the appropriate government. Appropriate government, what appropriate government does? Makes a labor court and a person is appointed for that. Qualifications. What are the qualifications of this person? What are the qualifications of this person? He has to be a judge of High Court. He has already been a high Court judge. He has been a district judge. Held in any judicial office in India for at least 7 years. He has been presiding officer of a labor court for at least 5 years. So these are the qualifications for the person to enter into the labor court. What are its disqualifications? Not an independent person. If he is an independent person, then only he can go to the labor court. If he is not an independent person, then he cannot go to the labor court. He must be of the age below 65 years. If he has touched the age of 65 years or above, then he cannot be given the responsibility of a labor court. What are the powers of a labor court? Inspection of a premises. The presiding officer, the person which we are talking about, after giving a reasonable notice, may enter the premises for inquiry. Every labor court shall have the powers of a civil court. All the members of the labor court are public servants. Labor courts. Constitution is what? Appropriate government appoints the labor court and the person, presiding officer. Then we have discussed the qualification of the presiding officer. And what are the qualifications? He has to be a high court judge, district judge, judicial office. He has to hold presiding officer. He has to be. What is disqualifications? He is not independent. He has attained the age of 65 years. What are the powers of the labor court? The powers of the labor court are that the presiding officer can give a reasonable notice to the premises and he can go for inquiry or investigation. Every labor court has got the powers of a civil court and all the members of the labor court are public servants. Conciliation officer. As we have discussed, there are two authorities in conciliation. In our earlier question, we have read that there are two authorities in conciliation. The conciliation officer and the board of conciliation. And the employer has to go appoint the conciliation officer for negotiations and all. So now we are reading particularly about the conciliation officer. Appointment. Appropriate government appoints conciliation officers to act as mediators in the settlement of dispute. We have read this already. The conciliation officers act as mediators for the settlement of the disputes between the employers and the employees. What are the duties of conciliation officer? Duties are not judicial and only administrative. The duty is only administrative. He coordinates the matter between the two rival parties, that is the employer and the employees. He fixes date, place and sends notice to both the parties that on this date at this place we will have a negotiation or a discussion. If parties participate in conciliation and come to a settlement, then it is called settlement of disputes. What are the powers of the conciliation officer? Power of a civil court. He is a public servant and he has to follow the principles of natural justice. Conciliation officer. Appropriate government appoints conciliation officer and he will act as a mediator between the two rival parties. What he does not exercise any judicial powers, he has only administrative powers. He fixes the date, time and place of the meeting and conducts a meeting between the two rival parties and tries to settle the dispute. What are his powers? He is a public servant, he has to follow the principles of natural justice and he exercises the powers of a civil court. What is court of inquiry? Court of inquiry. Object of establishing court of inquiry is to make an investigation, as we have discussed, investigation into the facts. It focuses only on the facts. The appropriate government may constitute a court of inquiry. It is not a permanent body. It is a fact-finding body. Only for finding the facts in the particular case, the appropriate government constitutes this court of inquiry, and after that purpose is over, it is wound up. It is wound up. So when there are proceedings pending with the conciliation officer or labor court, the rights of the parties are affected. They cannot and they are not allowed to do strikes and all. When their dispute is pending before the labor court, the parties cannot do a strike simultaneously. So when a proceeding is pending with the court of inquiry, the rights of the parties are not affected. Workers can still go on strike. This is the main difference between the court of inquiry and any other court for dispute settlement. If the case is with any other court like labor court, conciliation officer, then when the case is pending, the workers cannot go on strike. But if the case is pending before the court of inquiry, then the workers can go on strike. So what is court of inquiry? The appropriate government constitutes a court of inquiry for a temporary purpose, just to investigate into the facts of the case. It is a fact-finding body, and the rights of the parties are not affected. Now what is domestic inquiry? As the name itself suggests, it is an inquiry conducted internally by the management. Let us try to get the solution, let us try to get the answer from the question itself. Domestic means within. Domestic means like inside your house or inside internal. So domestic inquiry means inquiry which is done internally. As the name itself suggests, it is an inquiry conducted internally by the management. The management constitutes a disciplinary board. A disciplinary board is constituted by the management. This disciplinary board is constituted. This board appoints one or more inquiry officers. Inquiry officers are appointed by this board. The inquiry officers must follow the principles of natural justice. It is required in every establishment to inquire into the misconducts of its workmen. Reasons are, for every misconduct, the management cannot go to the labor courts as it involves time and cost. For every confusion which arises in the business, the management cannot go to the labor court. It is a lot of time consuming and it is costly. So what they do, they set up a disciplinary board and inquiry officers are made. Inquiry officers internally inquire about the misconducts happening in the business. Employer cannot make allegations against his own workers. He cannot terminate his own workers whenever he wants. So because of these reasons, this domestic inquiry disciplinary board is set up. So what is domestic inquiry? Inquiry conducted internally by the management. The management constitutes a disciplinary board. The board appoints one or more inquiry officers. They must follow the principles of natural justice and they inquire into the misconducts of its workmen. And the reasons are, for every dispute or every misconduct, the management cannot go to the labor court as it is very time consuming and costly. Employer cannot make allegations against his own workers. He cannot terminate his own workers whenever he wants. Inquiry report. An inquiry officer is appointed by the disciplinary board of an industry to conduct an inquiry into the misconduct of an employee. We have read in this question that the employee, the management sets up a disciplinary board, and the disciplinary board appoints inquiry officers. These inquiry officers investigate and prepare inquiry report. An inquiry officer is appointed by the disciplinary board of an industry to conduct an inquiry into the misconduct of an employee. After completion of the inquiry officer submits an inquiry report to the disciplinary board. This inquiry officer submits an inquiry report to the disciplinary board. Such inquiry report is a summary of the findings on the charges arrived by the inquiry officer. Charges means the allegations against the employee. On the basis of the inquiry report, disciplinary board gives its decision. When the inquiry officers give this inquiry report to the disciplinary board. On the basis of this inquiry report, the disciplinary board gives it decision. What are the contents of the inquiry report? Name, address and designation of the accused employee, that is details of the accused employee. Name, address and designations of the witnesses, details of the witnesses. Inquiry officer must record all the evidence in writing. Report must be in good faith. Contents of the inquiry report: accused employee details, details of the witnesses, the evidence must be in writing and it must be given in good faith. Charge sheet. Statement of charges against an employee. The name itself says charge sheet means the sheet of charges against the employee, to give him a notice of allegations against him. It is a statement of allegations against an employee. Now, what are its contents? Name and address of the employee, details of every allegation, name of the complainant and witnesses. It should not be vague. Evidence must be disclosed. It must be fair, and it should not contain any hypothetical statements. So, what are the contents of the charge sheet? Details of the employee, the person. Details of the employee, accused employee. Details of the complainant. Details of the witnesses. Details of the allegations made. Then 4 general points. What are the 4 general points? It should not be vague, evidence must be given, it must be fair, and it shouldn't contain hypothetical statements. So what is charge sheet? Charge sheet is a statement of charges against the employee. What are its contents? It contains the details of the accused, details of the complainant, details of the witnesses, details of the allegations, and 4 general points. It should not be vague, it must be fair, evidence must be given, it must not contain hypothetical statements. Disciplinary proceedings in industries, meaning a set of rules or methods for regulating practices in an industry. Disciplinary proceedings means a set of rules for regulating the practices in an industry. For successful running of an industry, there are 3 important factors: money, management, and employees. For running an industry successfully, there are 3 important factors: money, management, and employees. Every employee should work with the feeling that industry is his own. All employees and management should work in a disciplinary manner. Disciplinary proceedings. The management cannot take disciplinary action against an employee the way it wants. It would follow law and principles of natural justice. The procedures which should be adopted by management are called disciplinary proceedings. The procedures which the management adopts are called disciplinary proceedings. Disciplinary proceeding is a written step-by-step process which a management should follow in every case where an employee has to be warned or dismissed. Failure to follow such fair and transparent disciplinary procedure may result in legal penalties on the part of the management. So disciplinary proceedings are a systematic step-by-step procedure that the management has to follow to remove an employee. If these procedures are not followed, then the management will be liable for legal penalties. Disciplinary proceedings in industries. These are a set of rules, 3 important factors: money, management, and employees. Employees should work as if the industry is his own. The management should follow the disciplinary procedures. Disciplinary proceedings. The management cannot take disciplinary action the way it wants. It has to follow natural justice. These procedures are called disciplinary proceedings. It is a written step-by-step process. Failure to follow will lead to legal penalties. As we have seen, I am just reading the blue points which I have colored. Adjudication or compulsory adjudication. Compulsory adjudication was first introduced in India during the Second World War to maintain industrial peace. Steps of settlement of disputes. What are the steps for settling the dispute? Conciliation. The first step under the act is the conciliation. Then, if conciliation fails, then the parties go for arbitration. If arbitration fails, The appropriate government may refer the dispute to adjudication. So the three steps are CAA. First conciliation, then arbitration, then adjudication. There are three kinds of adjudicatory machinery, and for this adjudicatory machinery there are three kinds again: labor court, industrial tribunal, and national tribunal or national industrial tribunal. Labor court, industrial tribunal, and national tribunal. Or you can write IT like this, and NIT it comes. National Industrial Tribunal. So what is adjudication or compulsory adjudication? Compulsory adjudication was first introduced in India during the Second World War to maintain industrial peace. Steps of settlement of disputes, there are three steps: conciliation, arbitration, and then adjudication. Adjudication again has three kinds of adjudicatory machinery: labor court, industrial tribunal, and national industrial tribunal. The last question, 41st question, minimum wages. Minimum wages. Minimum wages are not defined in Minimum Wages Act. Minimum wage is the lowest wage below which efficiency. So the minimum wages are not defined in the Minimum Wages Act. Minimum wage is the lowest wage below which efficiency of a worker is affected. It includes not only basic necessities but also some comfort. It must provide for some measures for education and medical benefits. Thus, minimum wage is the minimum payment which an employer has to give it to its employee. Appropriate government fixes it and the employer is bound to follow it. Employer has to follow irrespective of his profit. So what is minimum wage? Minimum wages are not defined in the Act. These are the lowest wage, which includes some amount of comfort also. Basic facilities like education, medical benefit. These are fixed by the government and the employer is bound to follow them. Thank you for watching my videos, friends. If you find my videos useful, please click on the like button just below the video. Click on the subscribe button. It is displayed in the red color as shown here. Third step, click on the bell icon to get notified when I upload new videos. When you click on the subscribe button, it turns white color and this icon will be displayed. Click on the bell icon. With this, when I upload new videos, you will be notified automatically. Thank you so much.